afternoon. I'd like to reconvene the Planning Commission meeting of July 9th, 2015. Thank you, Al. So our next item of business is our two public hearings, 2015-029B, appeal of the Calaveras County Air Pollution Control District's finding that the California Environmental Quality Act, CEQA, applies to an application for authority to construct for an asphalt plant at Hogan Quarry. And also 2015-029C, appeal of the Calaveras County Environmental Management Agency, administrator's determination that the asphalt plant's evaluation under Calaveras County Code section 17-42-035 is a project requiring environmental analysis under the California Environmental Quality Act. So the staff report is going to be covering both of these items, and because they're so related, so the presentation will cover that, and the discussion, certainly we can cover both of those. When the action comes back to the Planning Commission, we will be taking action on those items separately. So with that, I'm going to turn it over to Peter.
Thank you, Madam Chair. Good afternoon, Peter Maurer, Planning Director. You described what's before you, and just up there on the screen. This is appeal of a very specific determination made by Brian Moss, sitting as both the Air Pollution Control Officer as well as the County Health Officer on two different but related issues associated with the proposed asphalt plant. A application for authority to construct was submitted to the Air Pollution Control District. The application was deemed incomplete. In the letter that was returned or that was sent to the applicant, it was stated that this action, when they submitted a complete application, would be subject to CEQA, as well as his determination under section 1742-035. Get this closer to me. I'd like to point out that on the previous action that you took, which was my determination that a use was permitted under the code provisions of the general industrial zone, we did not go beyond the point of looking at what that section of the code said and what the history was. We did not look at 1742-035, so that was not a part of that previous discussion. So whether or not a conditional use permit is ultimately required was not something that I considered. We were frankly not aware of that provision in the code until it was brought to us later on. So this appeal that's before you today is not about the ultimate determination of what the ruling is. It's just whether or not the actions by the health officer and the air pollution control officer are subject to CEQA. So it gets down to an issue of what is a project as defined by state law. And the Public Resources Code, section 21065, defines it as an activity which may cause physical change to the environment and is one of the following. It's an activity that's undertaken by a government entity, such as building a road, putting in a new jail, those kinds of activities. That's subject to CEQA. It's an activity that is funded by a public agency. So it could be a private project, but if it's funded by the state agency, that would also need to go through the CEQA process. Or it is when an agency issues a permit, a license, some type of entitlement for a private party to carry on. Those are the three provisions in state law that address what a project is. It's further elaborated through the CEQA guidelines that is, and they call it a discretionary project in that case, is where there is judgment that is used by the agency or body that is approving the project. So if it's a straight, just simply apply the standards, such as a building permit, that's not discretionary, that's not considered a project under CEQA. But where it is something where we use independent judgment, we apply conditions, such as a conditional use permit or a variance or a tentative map. Those are where you as a planning commission or myself as staff apply our professional judgment. We take into consideration concerns of the neighborhood, of all the issues that we need to address, and we have the ability to apply conditions. It's further been refined by some case law, where it's where the agency in approving a project has the ability to shape the project to protect environmental resources. So those are sort of the definitions of project that we're dealing with here today with these two determinations. So the first one is the authority to construct that would be issued by the Air Pollution Control District. And under the APCD rule 401, authority to construct is required when a person or business or some entity proposes to install, construct, or use equipment which may result in the issuance of air contaminants. So whenever someone is proposing some activity that would have the potential for air pollution, then an authority to construct is required. The authority to construct is reviewed by the district staff or its contract engineer, and can be approved, conditionally approved, or denied, and the conditions may be applied to reduce the release of air contaminants. So in our minds, that falls clearly under the discretionary provisions of the definition of a project. With the health officer's determination, the project proponent is required to submit to the health officer the list of substances used or produced in the proposed operation. The health officer reviews those substances and makes a determination whether the type, method of use, or quantity of substance may have a significant effect on the environment. And if there's a significant effect, then he is to report to the planning director that that is the fact, and then I would require a conditional use permit. This is sort of a decision tree of how the process works. And in the case of the proposed industrial use, we start up here. And with the Air Pollution Control District, the first question on determining whether it's subject to CEQA. And I'd like to point out that CEQA has a range of different requirements. You can, could be exempt. There's exemptions that you can apply. We would file a notice of exemption. It could require a negative declaration or a mitigated negative declaration. That is where there are no impacts. It's still subject to the creation of a document, but there are either no impacts or the impacts are such that they can be fully mitigated. Then you can file a negative declaration. Or if the impacts are significant and cannot be mitigated, then an EIR is required. So there's a full range of different types of CEQA documents that could be required depending on the nature of the proposed use. So the first question then, is a permit to be issued in this case? And for the Air Pollution Control District, yes, a permit is issued. Second question then is, are conditions applied? Yes, conditions may be applied. So at that point in time, we would review an application, determine whether there's an exemption, or do an initial study. Once the initial study, if that's the path that we would need to take is completed, then we would, or if it's exempt, we would prepare the document, go through the public review process, and prior to approving of a project, the CEQA document is approved, and then the authority to construct would be issued or acted upon. With the case of the health officer's determination, first question is a permit issued? In this case, no, there's no permit issued. Secondly, are there conditions that can be applied to shape the project to reduce environmental impacts? No, it's a yes or no question. Are there substances that could affect the environment, or are there not? If that determination is made, basically answering these two questions here. If it's yes, then it requires a conditional use permit, and then we get into these questions down here as to, is it a project or is it, do we issue the permit? If it's yes, then we go through the CEQA process. If the determination is no, there are no substances that could cause an environmental effect, then the answer is no, and the use is permitted by right as our code allows. So where we are at this point in time is at this level right now. We have not got down into this level yet. So the decision made by the health officer and the air pollution control officer was simply whether or not, or at the time that the appeal was filed, it was simply that these are project under CEQA. Now, you might be asking, why are you saying no when we told them that it was, yes, it was a project? After looking at this more closely, we have determined, and we are reversing our finding, that the determination under 1772-035 is a project. We do not believe that it is a project, and that is included in the recommended motion to you. However, when, subsequent to the filing of the appeal, you have copies of letters in your packet that shows that Brian did make this determination. The answer was yes, and we've notified them that conditional use permit is going to be required after all. But that is not before us today. It's simply at this level is what the appeal is at. Is there any questions?
Yes. You mentioned that with respect to your decision on the zoning, 035 wasn't considered. And I think you said you didn't know it was there, but 035 speaks only to the health officer, correct? Doesn't speak to the planning director.
It directs that the project applicant submit to the health officer the information necessary to make a determination. And then it's deferred back to planning.
Now, secondly, you mentioned EIRs as the third level of environmental review.
Yes.
And are EIRs only applied, and you use the word where no mitigation is possible. So EIRs don't have a mitigating component to it. It's when all else fails, you go to an EIR. Is that a way to put it?
Not exactly. When you do the initial study, you identify, are there any significant impacts? The next stage of that is identify potential mitigation measures. If you can mitigate all of the impacts, then you can file a mitigated negative declaration. If you find through the initial study that you cannot mitigate them, you go through the EIR process. You still would apply some mitigations, but it may be that at the end of the day, there are some impacts that cannot be mitigated, and then the decision maker can make the determination whether or not the benefits of the project outweigh the environmental impacts. And that's the whole purpose of CEQA, is to have an informed decision on what are the environmental effects of a project.
And in the mitigation stage, when you're talking about mitigating factors, is that where the applicant and environmental, or you, we're actually going to get to this in a minute, but you bring up a problem. I see a problem with this component of air pollution. The applicant says, that's taken care of by this particular machine because it's got a XYZ filter on it. And that either satisfies you or it doesn't. And then so you go through a list of concerns, and the applicant, you're sort of in the same room, or there's a back and forth.
Yes.
And you're talking about what's possible and what isn't possible. Or if you say, hey, you know of a procedure where this can be mitigated, they hadn't considered that, and then they say, yeah, we'll go along with that. That kind of a process?
Exactly.
Okay.
So you identify what the impacts are, you identify potential mitigation, you determine whether or not they would reduce the level of significance to less than significant. And then if if the applicant agrees to those mitigation measures, then you can move forward on a mitigated negative declaration.
Okay. Now, in the interest of disclosure, you answered some questions for me privately a couple of days ago about the left side of the decision tree here on the air side, Mr. Moss wearing his air hat, if I can use the vernacular in that sense. And if you get down to the bottom of that decision tree and a CUP is being called for, it is your office that actually performs the work of that job, right? His office doesn't do it. You do it in conjunction, in consultation with his office and his staff. Am I right about that?
That's correct. The planning department would take the lead on any conditional use permit. We would be responsible for processing the environmental document, but we would coordinate with all the other agencies, county level, as well as outside agencies.
Right, you're going to Public Works, you're going to wherever you need to go.
Right.
And how like or unlike would that process be to the process of a conditional use permit if we were talking zoning 2 weeks ago? How is that really pretty much the same process that you would go through if you had determined it wasn't a permitted use?
Yes.
Okay. A CUP is a CUP.
CUP is a CUP, correct.
Okay, now, I don't know if Mr. Moss is going to make a presentation or
He's here available to answer questions for you.
I have a couple. In the July 2nd letter, and let me start with the date. This came out a couple days a day before the 4th of July holiday weekend. And I'm wondering about the timing of that with respect to the fact that this has been on the table, so to speak, for a few weeks. And I'm concerned that the appellant didn't get a chance to, they had to scramble over the 4th of July weekend to, make some responses in large part that aren't going to be heard today because they were, the timing of them, they weren't noticed in time. And of course they couldn't be because of this July 2nd date.
Right.
So that concerns me, and I wondered about how the timing of this letter came about.
So the determination on the 2nd that there are hazardous materials that could cause a significant effect and the conditional use permit is a separate action to the determination we made earlier, drawing a blank on the date, sometime in May.
035.
That these two processes are subject to CEQA. They're related, but it's a separate action. And the appellant has 15 days to appeal that decision by Brian and I that it has a significant effect and a conditional use permit is required.
Yeah,
They can argue that, at such time as appropriate. We haven't had any time to prep for that. And I wasn't aware that they thought that that was part of this appeal until we received their brief 2 days ago.
Okay, maybe that gets to it. I know they have 15-day period, and they can appeal, and then we're going to come back and have this discussion again. And
it'll be narrowly focused to whether or not there actually is a significant effect on the environment.
Right. I guess what I'm saying, I'll make it more clear. If this decision had been made a couple of weeks ago, then we could hear the whole thing today. And so now we're going to get it kind of piecemeal.
I just want to add that I believe Mr. Moss received the application with the list of materials used at the conclusion of our June 25th meeting.
It was the time that it took for you to get the full list that created this July 2nd date. That answers my question.
In part, absolutely.
Okay. And then I just have one more question with respect to what is in our code for M1 and M2 zoning. And there's what's called permitted uses and conditional uses. And my concern is that, and actually I have another question. I'm going to back up. I'm going to save this one for the last. You cite Assembly Bill 1082 in your July 2nd letter, but you don't excerpt it that I can see. Well, maybe the excerpt is in that paragraph. Is that the only relevant excerpt from 1082? In that middle paragraph, page 2?
As far as the definition of what is a hazardous material?
As to what prompts 1082 to apply?
The reason that 1082 applies is because the Environmental Health Department is designated by Cal EPA as a certified unified program agency to carry out 6 different hazardous waste programs within Calaveras County. The issue with this is that in the past we were looking, well, of course we found out about 1742035. My point was that in addition to that, actually state law during the legislative session, I want to say it was 2000, passed 1082 that established the Unified Hazardous Waste Program, which we carry out today. So what I was doing is I was citing what state law says today, separate and distinct from 035, stating this is what is considered a hazardous material.
Okay. So that I and hopefully the public also understands is, does 1082 trump our 035, or is this a separate consideration altogether?
It's a separate consideration because I believe that county code is still valid.
Okay. All right. Then the final question that I wanted to get to was this issue with respect to, quote, permitted uses versus conditional uses. And we give the public a list of permitted uses for both M1 and M2, right? And then we give them conditional uses. And the question that this subject, and maybe I'm trying to make it too simple. I try to make things as simple as possible for myself because I'm feeble. But how does this impact the nature of our codes with respect to what we list as permitted versus conditional uses in those two industrial zones? Does it not, for the sake of argument, does it not suggest that everything that we list as permitted has to have a big asterisk on it with the footnote that says not necessarily?
That's true.
Can you explain how 1082 and or 035 doesn't create that effect?
I think it effectively does create that
Yes.
effect.
I'm sorry?
It effectively does create that situation. Any use that's normally permitted by right could be kicked over into a conditional use permit process because of the use of potentially hazardous substances.
It does put the asterisks on all those items, doesn't it?
Sure.
Okay. And so I don't know we can't get into the 035 process today, correct?
I think that what we're saying is that we're noticed for CEQA, so we can talk about 035 with respect to its applicability, to whether CEQA applies or whether it's a project under CEQA, getting into the substantive determination that wasn't made until July 2nd. We haven't noticed for that, we haven't prepared.
Yeah, I didn't want to cross that line there, but would you agree that is the determination under 1082 very much like the 035 process?
Actually, again,
Or does 1082, I'm interrupting you for a second, does 1082 simply say, here's your list of substances that are going to trigger this process?
1082 doesn't actually list, well, it may list substances under 6.95 health and safety, but what we were talking about under 1082 was a simple definition of hazardous materials as defined under 1082 adopted 6.95 of the Health and Safety Code, state law. So what we were citing here is what is a hazardous material. And so what I did is I quoted the Health and Safety Code section. And I think that, quite frankly, I think 035 It's kind of they are related in terms of how do you determine what a hazardous material is. Certainly, there is no list in county code that says this is a hazardous material and this is not a hazardous material. Unlike what you would think maybe 035 would have said, but that's not there. So what do? I go to the current programs that we currently carry out pursuant to state law to make a determination as to what is considered hazardous and what is not. So I think they're actually both applicable.
You're given a resource in the state to go to,
Correct.
a table. Well, not a table, but reference material.
Yes, and again, it's health and safety code.
Okay. Now, so does asphaltic concrete or the bitumen component of it show up on that list where, here's where we're getting a little conflicting information.
Agreed.
Can I just stop you for a second? I just want to make sure, the questions that you're asking now seem to go towards the substantive determination that he made, and I agree that whether he looks to state law or not is relevant to whether it's a project under CEQA, but if we're looking at the basis for his July 2nd determination, I don't think that we've noticed the public that that's at issue today.
So discussion about bitumen and asphalt and...
I'm having trouble seeing how that would
Well,
be
okay,
related to
all I'm doing
CEQA.
is looking at the letter of July 2nd, and it says that, which is the basis for his determination that it's a project and I'm questioning about how you get there. I mean, I don't see how that's not an illegitimate question.
I guess, I think the way that CEQA works is you don't have to look to the actual contents of any particular application to know whether or not an agency action is a project under CEQA. You only have to look at the process. So Mr. Moss did not need to have a complete application.
Oh, I wasn't talking about the application.
In order to determine whether or not an agency action would be a project under CEQA, you don't look at bitumen, asphalt, the specifics of the application. You look at what the action is asking the government to do and whether or not it's discretionary, whether or not it's ministerial, that sort of thing. And so, again, my concern is whether we've adequately noticed the public that we're going, I think in retrospect, we perhaps should have had two separate letters, one addressing the CEQA issue and one addressing the actual substantive determination under 035, and so I can understand there being some confusion, but I am just concerned as on a due process basis for going beyond the issue of whether it's of whether the 035 determination is a...
No, I'm not going to 035. I have no intention of going beyond the middle paragraph of page 2, the second half of it. That's all chapter 6.95, section 25501. The language that the health officer considered in his determination. Is that not a fair thing to do?
I think, again, as long as we're talking about why or why not it would be a project under CEQA, you're okay. If we're talking about justification or lack of justification for the final determination made on July 2nd, then that would be a different story. That's all I'm trying to say.
I'll tell you what, I'm going to go ahead and ask the question, and if you think I'm out of line, just interrupt me, because I'm not sure I understood the legal admonition there. But inasmuch as we've heard hazardous material, it is or it isn't. EPA says it isn't, maybe it's under certain conditions, and inasmuch as the public has heard both ways, how does the state give you guidance for that particular phrase, hazardous material, that may or may not be different than what we've heard?
Well, again, I would go simply to the absolute definition in that paragraph. Also following up with, quite frankly, and I don't want to cross over that line either, but crossing over into the MSDS, material safety data sheets, those kinds of things. And I hope not to cross the line here as well, so council, please jump in if I do. There is also some confusion as to what is asphalted concrete versus asphalt, versus the material that we're actually talking about, which we will discuss at the next hearing. The asphalt itself, in this case, comes from the refinery. And it is not necessarily the same thing we're talking about when we look at the pavement out on the road. Is that asphalted concrete? Yes, it is. Is asphalt made? Is asphalt a key component of making that? Absolutely it is. But
And
it's not the state that we're talking about.
I would just ask the planning commission to not rely on any information provided today with respect to the nature of concrete or any of that and any of its findings today. I think we need to see.
I know what it is. I know what you're saying. It's not a problem. Okay. That was an answer to my questions. Thank you very much.
Thank you.
Any other questions of Peter right now, or Mr. Moss? Okay, I would like to invite the appellant to address the Planning Commission, and since we're hearing both of these items together, an allowance of more time, than the 15 minutes, so.
Good afternoon, Diane Kinderman with the law firm of Abbott and Kinderman, Sacramento, California. Thank you, Madam Chair. I'm distributing an email that I sent late yesterday. I am not entirely clear on what we're hearing today. We received a letter from planning staff at 4 p.m. last night that told us that the matters we believed were before this commission are not being heard today. And we disagree with that. And this was the email that I sent to staff, and I'd like to go through that because it appears as though our substantive issues are not going to be addressed, because we believe we are down much lower in the chart all the way, and I'll explain why. So if you look at the email, it just says, "Thank you for your correspondence. We have the following 4 responses for the record. We disagree with your letter's interpretation of the scope of the hearing tomorrow. In fact, the May 29 correspondence from Mr. Moss, which is the subject of our 2 appeals and which were noticed for tomorrow, one having been continued on June 25th, raised all of the issues addressed in our brief dated July 7th. And in fact, that is the case. At the time that that letter was drafted by Mr. Moss, he had the ATC application, which had the MSDS sheets on asphalt and diesel. No new information related to what they're now claiming would require a new determination was submitted after May 29th. So his decision on May 29th, he had those MSDS sheets already. We just resubmitted the whole package again when they asked for more information. So those were the subject of, were considered in his letter and are the subject, should be the subject of this appeal. Then second, and we've already dealt with that issue, that has to do with the findings which were just adopted on the other matter. Third, the 2 pieces of July correspondence, in our view, are nothing more than briefs. Just because they call them determinations doesn't make them a determination. Those determinations were already made in the letter of May 29th, and I will read to you what was said in that letter. A letter at which time they already had the application with the MSDS sheets and knew that it involved asphalt. And what it said, just that specific language is, after consultation with the planning department and county council, the county has determined that the issuance of the ATC and the determination under 035 is a project, as defined under the California Public Resources Code. And then they said, upon the submittal of more information, we'll conduct an initial study, making a decision that it's a project subject to CEQA. So that is the subject of this appeal. And I'm not clear whether or not you're going to take any evidence on any of these issues, but I would appreciate this being clarified. And our July 7th brief responds directly and quotes staff's arguments in their June 25th staff report. So we respond directly to what has already been before this commission. Moreover, the notice specifically stated this had to do with whether or not a conditional use permit was required for Hogan Quarry. period. And that's what your notices state as well, the notice of the hearings. So we believe that our July 7th correspondence directly responds to issues that were before this commission. And in fact, this commission can make a decision on these substantive issues because we're way down on this chart. And I'm happy to answer any questions about that. If the decision stands that, in fact, we cannot provide that evidence and a decision cannot be made, I would appreciate having that clarified right now. But what this is going to result is we're in the middle of appeal ping pong here. How many appeals do we have to file to get a determination made by the Planning Commission on these substantive issues that we thoroughly briefed based on what was in a staff report back in June? So I'm mystified as to where we're headed here, please.
So maybe what we should do is have a discussion with the Planning Commission regarding the scope of this hearing and inclusion of the appellate's issues regarding Mr. Moss's materials list and how he came about determining that asphalt was hazardous. Is that correctly?
For me, it was the timing issue, and I think Ms. Kinderman just brought that out. I asked the question about how the July 2nd letter didn't come out until July 2nd, and the answer was with respect to the materials requested from the applicant and then subsequently submitted, and I got a confirmation that, yeah, it wasn't until they were submitted that he could make this determination, and so he did. Now, I'm hearing from Ms. Kinderman that all of the relevant information, including the information to make this determination, the MSDS data sheets had been previously...
On May 18th, they were all submitted already.
I don't know the entire list, but
Yeah.
if there was nothing new that resulted in the July 2nd determination, then what happened?
I guess I just want to try to clarify the issues. Obviously, it's for the Planning Commission to determine how they want to proceed. I think one issue is whether or not we treat each staff decision as its own separate decision. So far, under the county code, there's a requirement that a staff decision be appealed using a particular process with 10 days advance notice to the public of the topics. And so we've had an appeal of the April 30th planning director's determination. That was by My Valley Springs. We had an appeal by Ford of a determination made on May 29th, I believe, by the environmental health officer, and that was related to CEQA. And I know that there's discussion about whether or not Mr. Moss should have made his determination earlier or not, but and maybe he can speak to that if the Planning Commission has any questions, but he didn't make his determination until July 2nd, and we have not received an appeal of anything other than CEQA. So again, certainly the Planning Commission's decision, my concern is that we haven't followed the procedure and noticed the public. I think the fact that the word CUP made it into one of our notices was clearly within the context of whether or not a CUP would be required under M1 or M2. And so, again, my concern is whether we want to proceed without a notice to the public. I will say this, if the Planning Commission does choose to go forward and hear those issues, I need to just alert the Planning Commission that because I didn't receive the brief until less than 2 days ago, I haven't had time to research the additional issues related to the constitutionality of 035, et cetera, so you would not have the benefit of any of my research. So that would be up to the Planning Commission to decide how they wanted to proceed.
So in which case you would
I would
suggest
request
a continuance?
Yeah, so if the Planning Commission does choose to go forward, treating it as part of the same appeal, I would, ask that you exercise your discretion to continue the matter so there's enough time to address it. So there's two options, I think.
May I make one
Give us those
correction
two
in the
options
record?
again, please.
Well, I think there's really three options. One option is that you could continue the hearing and hear all of the issues today. The other option.
No, continue means don't hear them today.
Right.
No, continue with the CEQA,
let me
the CEQA
clarify.
discussions.
Oh,
So the staff recommendation is that that the July 2nd determination by Mr. Moss be treated as a separate appeal, noticed separately, heard separately, because it's involving fundamentally different issues than CEQA. Okay? That's one option. That's the staff recommendation. The second option would be if the Planning Commission disagrees with that and feels that, and agrees with Ford that they should all be considered as part of the same appeal, you could exercise your discretion to continue the matter so there's enough time to research those issues and then just hear it as part of this existing appeal that we're hearing today. Or the Planning Commission could say, no, we want to hear them today regardless, and can hear them today even though I know staff and certainly myself haven't had any time to research the issues. So those are, I think, the options before the Planning Commission. We probably should make a preliminary determination before going forward.
Okay, so.
Can I make one correction in the record? I beg your pardon. We filed 2 appeals to the May 29th letter because of the way it was drafted. One on 035 and one on the ATC CEQA determination. So
right.
we did file 2.
Right.
I just wanted to make that clear.
Right.
Okay.
And I just, and the 035 one, though, was related to CEQA and the applicability of CEQA to 035.
Right, and
Okay.
I have a suggestion. Do you want to talk first? I could give you a
No, go ahead.
suggestion. It might
No, I want
help.
to hear what you have to say.
We're all intelligent people, we all know CEQA, and we all kind of can get along. I'm wondering if perhaps, if this is continued if you're really not ready to make a decision, even if you allowed us to argue today, if you really don't feel comfortable making a decision, if we had a brief continuance to a week, perhaps, I don't know what your schedules are, to maybe a week, and give us an opportunity to work with staff and see if we can withdraw the appeals, perhaps, if that might be possible.
The only issue with that is that if the Planning Commission agrees that the requirements of the county code need to be filed with respect to separating the issues out and making sure the
Correct.
issues are noticed, there is a requirement that they be published 10 days in advance.
All
And then,
right.
of course, that also involves the newspaper's timing for when it
That's
can.
right.
So it depends on how the Planning Commission, I think, feels about that.
Right. Well, in that regard, I'd just soon argue today and get a result, but I understand you have to make that decision. Thank you.
Commissioner
Okay.
Wooster.
Looking at the May 29th letter, that is a foundation for the applicant's view that it all ought to be heard today. It does these things. It says the county has determined that the issuance of the ATC and the determination under section 17.42.035 is a project. Those are 2 different things. As I understand it now, the county now agrees that the determination under .035 is not a project. And all we're being asked to do on that is sign a resolution that confirms what everybody agrees to, which is it's not a project. That's pretty simple. Now we have the issue of the ATC. Is that a project? That appears to be a live issue. It's properly noticed. We can hear it today. Now we have the further finding in the May 29th letter that upon submittal of the above requested information, the county will conduct an additional study, etc. I now understand that the county agrees that that statement was premature. And we are not being asked to sign a resolution that says that it will conduct an initial study. That doesn't seem to me to be too difficult either. So the only real question here is on the ATC and whether or not that is a project or it is ministerial, which is the argument as I understand it. So it turns out not to be a project. I don't know why we can't hear all that today. The decision that Mr. Moss made under 035 is a different thing. He did it on July 2nd. It involves different issues. I don't think the public has had adequate notice of that. County Council hasn't had enough time to look at it, and I don't see any way that we should be hearing that today.
Julie, just for some clarity purposes here, when I'm looking at C, the health officer's determination, this is under the project, that a review of a use pursuant to section 17.42035 is a discretionary project. That's not public notice that 035 is being sent out, and then when I look at the letter on May 29th, it does reference 035, and then, so give me some clarity on that.
So the notice went out describing the issue as being whether it's a project, whether 035 is a project.
Okay.
Under CEQA. There was no notice about whether or not Mr. Moss was correct in determining, using 035, that the materials used by the asphalt plant may have a significant effect on the environment, or whether that code section should be deemed unconstitutionally vague and therefore not relied on by Mr. Moss. None of that has been noticed. Those are outside of the issue of CEQA. And so what we talked about at the last hearing was how the CEQA issues were going to be continued to today. And what we noticed the public is how the CEQA issues were going to be continued today. And so my concern, again, from the due process standpoint, is that we have a host of new issues involving a later decision that were raised only in a brief, the title of which referred to CEQA. So we have a bunch of new issues that instead of being raised by virtue of a new appeal, were simply raised in briefing and have merged two different staff decisions. And that's my concern.
So the letter that came out on July 2nd, because it was referencing both items, has caused a little bit of confusion, but
I
it
think
came
so.
too late for public notice.
I think that the letter was involved again, in retrospect, it probably would have been a smarter move to write two separate letters. And I think the confusion is because we have two things in one letter. One is addressing an amendment to a May 29th decision, which is at issue today. And the other part of the letter was, I've now completed my review under 035 and issued a substantive determination. And so we attached the whole letter to the Planning Commission's staff report, and the result is some confusion about what issues are at play. And then receiving a brief, and perhaps the applicant also was confused or was thinking that that would be at issue today as well, and briefed all of these issues that go beyond CEQA. And so to keep it clean and to make sure we understand which staff determinations we're actually hearing today, I think the staff recommendation and my recommendation would be that we separate these out. And separately, there's an issue of, we are required under the county code to notice the public of what issues are actually going to be heard on appeal. And it's one thing if there's sub-issues raised in a brief that are related to the issue that's being noticed, but when we're going to a completely different staff determination and completely different topic, there is a real argument there, in my view, that there hasn't been adequate notice.
Mrs. Kinderman, when you read the appeal, do you see anywhere in here where the appeal that was noticed to the public would open up the discussion that on 035 that you're wanting to go to?
I don't have that in front of me. I was relying on what was in prior notices before June 25th, and then the hearing was continued to a date certain, July 9th on it, so I don't have that one in front of me at this moment. But what I do have in front of me, and what we addressed in our staff, in our response, or our brief, was everything raised in the June 25th staff report, which is why I viewed their July 2 letters more as briefs as opposed to determinations. So
did you get a copy of the staff report?
yeah, I don't have
Do
it
you
in
wanna
front of me
look at
right
it?
now.
Because-
But I'm talking about the notice of this hearing, which
Okay.
was on June 25th and then continued to a date certain, that specific notice, which I don't have in front of me right now. So that notice, in addition to the issues raised in the staff report that we responded to and actually quoted in our brief in the June 25th staff report.
If I hear you correctly, Ms. Kinderman, you seem to be indicating that because the letter was attached to the staff report, that somehow would be the same as giving notice under the county code of different issues being raised?
That's how it is.
I don't have the, I'm happy to look at it. I know that we have noticed that there was going to be a CUP, that this issue was going to be discussed back on, after June 25th.
Because the notice, if I remember correctly, was issued June 12th, and that was 2 weeks before Mr. Moss made his decision.
Right.
So I guess I'm having trouble understanding how the notice.
The notice
of
was
the hearing
later
could have
because you
encompassed
forgot to notice not you, but somebody forgot to notice the 035 issue prior to June 25th. Remember, that's why we couldn't discuss
The
it?
CEQA issue.
Yeah.
Right.
The CEQA.
The hazardous materials issue.
No, I
On
think that's.
1742-035, we filed 2 appeals.
Right.
One on the 1742-035, the other on the ATC CEQA determination. Somebody forgot to notice it for June 25th, and so it was then noticed subsequently for July 9th.
But it was noticed as a CEQA issue, not as a substantive issue.
I just don't have it in front of me. When I went through our briefs and I looked at it, I believe they were noticed. So, and all the issues were raised in the June 25th staff report that we were responding to.
While you're looking that up, Commissioner Materdy's comment is that it's item C on the staff report. How do we get around that then? If we're not to discuss 035, the 035 decision, here it is as item C in the project.
Well,
The letter you're looking for.
it says the health officer's determination that review of a use pursuant to 1742-035 is a discretionary project subject to CEQA. That's the issue that's listed as item C.
Okay, so without looking at the following material, which says the parties agree that it is not, correct?
Correct.
Okay.
Ted, do you have any? Well, I think that Commissioner Wooster summarized quite well and eloquently, and, I agree with him completely that, about the issue before us today, and that being, is an authority to construct a project under CEQA, and I'm, fully prepared to deliberate on that issue today.
Are you looking for consensus?
I think we need to decide, given the options that Julie mapped out for us. One being proceed on the 2 hearings, one reversing the determination by the health officer, the other one is an authority to construct a project under CEQA, or saying that we think that the other issue about about the hazardous materials is aligned enough or integrated enough or somehow that we should continue the hearing to allow for preparation for that and proper noticing?
I have 2 agreements to make. That the finding, appeal, ping pong match is not a very efficient way to adjudicate this issue. But it looks like we're kind of stuck with it because of whatever, misunderstandings or improper notices or whatever, a series of issues, really, not just 1 or 2. But that I'm also in agreement with proceeding with the agenda item that we can conclude today, and we can at least knock that off our list.
Okay, I've got 3 votes for continuing, or Commissioner Materis? Proceeding. Continuing our efforts today, not continuing to a date certain is what we're moving forward today.
So you just want to hear the 2 appeals before us today that were publicly noticed?
Yes. That's what I would like to do. So do we have a consensus that that's the direction we're going?
Yes, from me.
Okay.
I have concerns from looking at these letters that they did include the 035 in it, but since we didn't publicly notice, that kind of puts a little bit of a crimp in things, and we're not, obviously legal counsel's not even ready to move forward with it.
So I think maybe one of the things that needs to be clarified is, does the Planning Commission agree with staff that Ford would need to file a separate appeal of the July 2nd determination, so that we can at least let them know what they have to do, or is the planning commission preferring to treat it all as part of the same appeal and continue the entire thing to another date for the rest of it?
So, Commissioner Wooster, when you were discussing that, you were saying to go ahead and continue the discussion on that earlier?
I didn't say anything about what we should do about the July 2nd determination that this is a hazardous material, because I don't think it's properly before us.
Okay.
And I think it should be the subject of a separate appeal, because it is a separate decision, and it involves different considerations. It gets to the merits of whether there is, in fact, likely to be a significant effect on the environment.
And I would agree. So I guess
think
what
Ms.
we're
Ma-
saying.
Ms. Julie's question was with respect to whether or not the appellant should have to file a separate appeal on the ATC.
No, on the ATC, on the July 2nd determination by Mr. Moss that pursuant to 1742-035, the materials used are hazardous and may have a significant effect on the environment. That's the issue that's being
And
prolonged.
your position is that it's not covered under their existing appeal?
The staff recommendation is that that should be treated as a separate appeal. The planning commission doesn't have to take that, doesn't have to follow that recommendation, but I think we need to give the applicant some direction so they know whether or not they need to file an appeal by the deadline.
I'd like to hear from the applicant again on that isolated issue.
I would too.
Thank you, I appreciate you, and as do my clients, trying to sort through all this. And so your question, Commissioner, is, for me, on the 035 issue,
When you're referencing that through the appeals, we're looking at just CEQA as far as public notice. When we're speaking to the hazardous materials in the July 2nd letter that Peter Moss wrote, Brian Moss, just sit together, you guys, I'll get it right. When we're looking at that, so what we're saying is today we feel like we have a public notice for the CEQA portions of it only.
Right.
But in looking at the letter that Brian wrote on the 2nd, and then looking at your response
Right.
letter to that, you feel that that was publicly noticed already and that we should be able to speak to it, correct?
correct, and it was part of the record because he had all of that in front of him as of May 18th, and his letter, his determination was written on May 29th. He already had those MSDS sheets on those specific materials. So it was discussed in the staff report how determinations were made, and we specifically quote the staff report, the June 25th staff report, in our brief, which I realize nobody, or not everyone's had an opportunity to digest, because it was received from us on the 7th, because we got these letters on the 2nd, and we had to quickly react to those.
And Mr. Moss, he's wanting to.
Yes, thank you. First of all, I want to thank Kinderman and Associates for submitting the data they did at the last Planning Commission meeting on the 25th. I think there's some confusion that might actually help clear this up. If you were to look at the May 29th letter from the Air Pollution Control District, actually with the Environmental Management Agency letterhead, we have a bulleted section. One of those, the second one, is provide materials safety data sheets for all materials. Kinderman and Ford were kind enough to do that during the last Planning Commission meeting. Did they submit MSDS sheets prior? Yes. Did they submit all the MSDS sheets we needed to know what kind of material they're going to use as the asphalt? No. They did submit that, however, at the last Planning Commission meeting. Therefore, the result of the July 2nd letter and determination. So we couldn't, and it's still, the ATC is still under review, but even at that time, until we had that additional data that they were kind enough to submit to us, we couldn't even make the determination that we did until the 2nd. And I hope that that helps clear things up a little bit.
That clears it up a lot. So
Some
what that
MSDSs
tells me is
for-
he didn't have the information to be able to include this into the
Right.
appeal for discussion today, because we didn't have it before that appeal was finalized.
Right, and both diesel and asphalt MSDS sheets were submitted as part of the application, correct? I believe so. Yeah, they were. I don't have the copy with me, but they were in my copy.
I would have to look at the file, but I'm fairly confident that's why we actually wrote that in that manner, because we did know what the diesel was, thank you. As far as the actual material to bring in, we didn't know if they were going to be using a used oil, if they were going to be using a newer material, if they were going to be using asphalt that is actually made at a refinery. We didn't know what that was. And so, yes, indeed, they did submit MSDS sheets, but it was absent that, and we went through that with my staff several times looking for that, and I'm sorry to say that it may have been included, but for some reason we didn't get a copy of it.
Understood.
So thank you.
Okay, then I'll make a motion that we continue with the two CEQA.
I don't know that we need a
You want a
motion.
You just want to continue with what
But we
we're
do
doing?
need to, I think what you're looking for is that if Mr. Moss's determination in his July 2nd letter, if you want to appeal that, we suggest you appeal that action in a separate appeal.
Thank you. It seems like, though, I have to file 2 appeals based on both letters, is what we're going to have to do.
I'm not, I just, I guess I want to just have clarification for the applicant from the planning commission so that they're not confused about what procedure is being required. I just wanted to, if the planning commission agrees that this is a separate issue that needs to be separately appealed, we should see if there's 3 votes for that, or, informal votes, just so that the applicant is on notice, fairly on notice of, that they have, within a certain period after the July 2nd finding to file an appeal.
Okay, can you tell me what question would be before the commission
Yeah.
under those circumstances? And here's what I would like for us to avoid, is that we parse the issue into separate little pieces instead of treating it as a whole. 035, determination as a whole, rather than is it hazardous or not hazardous, and we split it all up and can't consider it as a whole, then I think we run into problems because it limits our decision-making process. We can't discuss, well,
I think the problem is that there are times when you have to make a CEQA determination based on the nature of a decision meanwhile the process of applying for a permit is going on, and a substantive determination about an approval or a permit is not necessarily going to be able to be made until a department has all the information. I guess, again, CEQA is a procedural issue. This is as Mr. Wooster, I think, very eloquently stated, the issue of Mr. Moss's final determination is very separate from, and requires him to conduct a very different analysis with more facts from the applicant than simply saying whether it's a project under CEQA, and that's why there's been staggered timing. So, and similarly, it could be that in a year from now, if Ford receives an ATC, there would be at some point other decisions that Mr. Moss might have to make with respect to the plant, such as issuing a permit to operate, and that decision might result in separate appeals. When you have a project of this size, there's a lot of different stages, at each of which the applicant has a right to appeal to different hearing bodies. And so it's pretty difficult, I think, to reach every possible issue related to Mr. Moss's different determinations.
I wasn't talking about every possible issue. I'm just trying
These 3.
to isolate 035 into one question.
Well, and
if that's not possible, then
And had we had Mr. Moss's determination based upon the material data sheets, I mean, it's theoretically, we could have heard that today had we had that and had it been properly noticed. But, and I agree, this is not like, the optimum situation where you've got,
appeal after appeal with new information coming in, but I think given what we have to work with and following the law, I think what I was hearing from the commission, that it is totally appropriate for us to proceed today.
Direction for the applicant.
And, well, I think I did, direction for the applicant to, if there's an appeal for Mr. Moss's determination, that needs to come separately. Did we want to take just like a show of hands, or ayes, or
No, I think
nays?
you just filled out on the...
Confused,
you-
totally.
I did?
Yeah,
I think,
can
Go
I
ahead.
ask a question of you? It just seems like 035 is really wrapped into this whole decision process before us today. Would it be better for you if we continued all of this and wrapped it all into one in the hearing? Or would it be better for you if we go forward with the two things before us today and then we deal with the other 035 issue later?
Well, good question. I would like a decision on the ATC, the ministerial versus discretionary nature, the CEQA issue on the ATC permit. I would appreciate the opportunity to discuss that today.
Okay.
On the 035 issue, it seems that the consensus is that there is an adequate notice for whatever that reason is. And so I'd rather not discuss that today and would rather wait until we have an opportunity to maybe even work through it with staff.
well,
But I'm going to have to file an appeal, so.
Lisa's question is, do you want to punt everything to a day when you can wrap it all up? Or do you want to just go ahead and allow this split to happen today? She's asking you which is better for you in terms of making your case.
And that's what I'm saying. In terms of the ATC appeal, I would appreciate the opportunity to go through the ministerial versus discretionary nature of an ATC permit today. It isn't really a long argument, but I think it's worthy of discussion. And then on the 035 issue, once again, this is how I'm viewing these two separate, they are separate legal issues. The 035 issue and that determination, it's under the zoning ordinance. This ATC issue is a separate CEQA issue. The zoning issue, you aren't viewing it that way, Julie?
I guess my concern...
I don't want to confuse them. See,
Yeah.
I'm viewing them as separate, which is why we filed separate appeals on it. And
I agree
maybe
with
we
you.
should.
I agree with you, Ms. Kinderman, that that the ATC and 035 are separate, and I think the next issue are the CEQA issues that are based on the May 29th decision, separate from the substantive 035 determination that has nothing to do with CEQA from
But it-
July 2nd. And so I guess what I'm, just for the record and for making sure we're giving clear direction to the applicant, would ask the Planning Commission to separate out the 035. I'm asking if the Planning Commission believes that the 035 CEQA issue, about which it appears that there is consensus between the parties on as to whether it's a project or not, is an issue that's ripe for hearing today and a separate issue from the July 2nd determination made with respect to 035, which is unrelated to CEQA. And I think that that needs to be parsed out for the record and clarified for the applicant.
I thought that's what I tried to do.
So is there consensus with the Planning Commission then that we can hear the 035 CEQA issue today where it appears that there's consensus? We can separately hear the ATC CEQA issue, which is on for today, and that with respect to the non-CEQA issues to do with the July 2nd 035 determination, that would be something that Ms. Kinderman would have to separately appeal. Is that-
Having it been articulated that way, I would punt all of them. Having, the way this has been articulated, I do not agree with the approach on a CEQA. I think, I don't agree with that approach, so.
You prefer to continue?
I think, well, we're going to have to continue if we can't make the decisions, the findings that we're requesting.
So you've just answered Lisa's questions. Ms. Maturiti's question from earlier. And your preferred method under the circumstances would be to push everything.
Because I don't agree with exactly the way the CEQA issue is being articulated. And so that I don't want to create any more confusion on these issues and have to.
It's not possible to create any more
I
confusion.
know. I think Ms. Moss Lewis and I need to talk and clarify and not, but I don't agree with the way it's being parsed out.
Well, it's basically, I think, the same
I
thing
think
that
the way we
Commissioner
appealed it was
Wooster said,
appropriate.
too.
I'll tell you what, the equities of this issue, to me, speak to as much confusion as there has been on this with improper notices and misunderstandings. To me, the equities point to let the appellant punt this thing to a date when it can all be wrapped up.
Correct.
And I think I would favor that, and I would give them their due on that, because I think they deserve it under these circumstances, much of which we have created within the confines of these halls.
Well, could I ask a question or two?
Yes, please.
So, am I understanding correctly now that with respect to the 035 issue of whether the health officer's determination, no matter what it is a project where everybody, your client, staff, seem to agree it is not?
Correct. That
Do you want us
determination
to?
is
Do you want us to
screening.
continue that?
No, you can
to a
make
later date?
We concur with that decision. That
So
it
we
is-
can sign a resolution?
That the determination is a screening process, and that was discussed in our brief, and we agreed with that.
So we can
What
go
has
ahead
not-
with that part?
Correct. What has not been further discussed, though, is the issue, beyond
That's a
that,
good
whether or
call.
not a CUP is required because there's a significant impact, and that CUP would require CEQA then.
Okay, now
So
my next,
that's been briefed as well, but I've been told we're not prepared to discuss that today, and I think it's going to create confusion if we do.
Now
But
we
we
have
do
this-
agree that the preliminary, they've conceded the preliminary, that screening process under 035 is not a project subject to CEQA.
okay, so we can proceed with that part.
Correct.
Okay. My next question is on the authority construct issue, which brings up, is it ministerial decision or is it discretionary and so forth? I thought I had heard you say you wanted to proceed with that today. Now am I hearing that you do not?
I'm hesitant to proceed with it the way I'm understanding Ms. Moss Lewis
because of the
as
construction.
describing it, the construction as it's been described to the commission. And so I'm hesitant I'd be happy to talk about it. I'm prepared to, it's a short argument and short discussion, but I'm not clear on the way Ms. Moss Lewis has articulated that issue to the commission. And so I would, if we have to punt on the other issue, I'd just as soon
Is
punt
it
on it
possible
as
to
well.
clear up that issue right now?
Yeah, what's problematic for you about that?
The issue is very narrow to me, whether it is a discretionary permit or whether it is a ministerial permit. And that's all there is to that ATC issue. Is it going to be discretionary and require some treatment under CEQA? I mean, it could be identified, even if the county deemed it discretionary and a project under CEQA, they could find it exempt. There could be an exemption under CEQA. But I don't even think it's discretionary. And that's what my presentation, I'm happy to talk about it if you like, but I'm not sure if Ms. Moss Lewis and I are on the same page as to what direction would be given to commission on that. What do you think?
I'm just going to maybe recommend that we take a brief recess because now I'm confused as well.
Okay, all right, that's okay.
And maybe we can speak for a couple of minutes.
Okay, let's do that.
Good
I like
idea.
that idea.
So we'll reconvene at 2 o'clock.
Thank you.
Thank you. At July 9th meeting of the Planning Commission. And there has been some movement during our recess. So I think what I'm going to suggest to the commissioners here, actually I am, is that we'll hear whether an authority to construct is a project under CEQA. We'll also hear whether 1742-035 as a project under CEQA. Both of those are on our agenda. And I would instruct the appellant that if you want to challenge any other part of Mr. Moss's July 2nd determination, that you would need to file an appeal by July 17th.
Correct. And we would be filing an appeal in the next couple of days, in the next day. How soon could we get notice? That's a question. My clients are very anxious and on a calendar. What would be the closest date we could get?
The quickest date?
Yeah. In fact, I'll call them when we're done here and say, file it.
I think Mr. Maurer will be able to help calculate that with you after the hearing.
After the hearing, thank you.
Yeah.
All right.
Okay, so shall we start again where we started a couple of hours ago about, your presentation talking about...
Right. Would Mr. Moss like to make a presentation on this issue again first, or shall I just go ahead with my very short
Why don't you go
comments?
ahead?
Okay,
Yes.
great. So one of the issues that we appealed was whether or not the authority to construct is discretionary or ministerial. And just for everyone who may not be familiar with what that is in the audience, a ministerial decision is one where the public official really uses little or no personal judgment in approving a project. They just have some standards that they apply and make sure that those standards, if those standards are met, they can issue the permit. It's ministerial. It doesn't have to go before an appointed or elected body to make that decision. And so in this circumstance, looking at the codes that govern the county APCD here, we didn't see any very clear standards on how that decision is made, whether or not an authority to construct is ministerial or discretionary. We also filed a Public Records Act request requesting CEQA documents for any authorities to construct that may have been issued in, I think, the last 5 years or so. We did not receive any CEQA documents as part of that Public Records Act request. So we are left with the conclusion that there aren't any authorities to construct that have been issued in the last 5 to 7 years that have required any CEQA analysis, that they have been treated as ministerial. And so our conclusion is based on our Public Records Act request and the response to that request. So what happens many times is when you're in a court situation and you have no standards and you're dealing with an air quality issue, a court will look at how another district might handle an air quality issue. And in Northern California, as the global warming issues have evolved and greenhouse gas emissions have become more and more of an issue over the years, in Northern California, the courts have looked to the Bay Area Air Quality Management District as to how they've done things. And nowadays, other districts are also held in high esteem, like the San Joaquin Valley Air Pollution Control District and some other districts and others in Southern California. But for Northern California, the Bay Area Air Quality Management District has always been held in high esteem as having appropriate standards for determining air quality impacts. And so what we did in our appeal correspondence was we talked about how the Bay Area Air Quality Management District might make a determination on an authority to construct, whether it would be discretionary or ministerial, because once again, we didn't see any guidance here in this county. So we thought, let's look at a jurisdiction that a court would find reputable. So we looked at the Bay Area. And they actually pursue an ATC permit review process as ministerial under specific conditions. And they actually have a specific section for asphalt hot mix facilities in the Bay Area. And so the 3 key issues that they look at are, 1, does the staff now, meaning the APCD staff, have reputable data to calculate the proposed project emissions? In other words, has the applicant submitted the appropriate information so the district can make their decisions about the facility? And we did that in the original application, and we've submitted additional materials, as Mr. Moss indicated, of prior tests done in operational emissions done on this facility in Siskiyou County, and it was found as to Siskiyou County that this was much lower than any of their emission levels, that it was an extremely clean facility. We just have not had an opportunity yet to set it up and have it tested here for this district, which hopefully will be done in short order. We don't know yet. So, one, does staff have the reputable data to calculate the proposed project emissions? And as part of that, you have to set up the facility, they have to run it, and they have to test it before they can issue an ATC. Next, the second criteria is, will that facility use BACT, B-A-C-T, the best available control technology that's listed in CARB's BACT clearinghouse? So the California Air Resources Board has a menu of options for appropriate technology, and one of those is a bag house, and the types of bag houses that are appropriate. And in this case, it is a state-of-the-art facility, and it has an up-to-date bag house, which reduces all, the emissions, eliminates emissions. And so we would fit that particular criteria as well. And then the third one is, after reviewing the data, will the project comply with the district's rules and regulations? And so because the rules and regulations are not, there aren't really any here, looking at the Bay Area Air Quality Management District rules and regs, we would comply with those. And so our argument is that if we were to look at the Bay Area standards, this would be treated ministerially, not as a discretionary approval. The next bullet says, the district, meaning this district, routinely approves ATCs ministerially with no CEQA compliance for identical uses. And I just give an example of, and we'll compare the plants in the next chart in a moment, but the all-rock asphalt plant's permit was approved without any CEQA. That was a couple years ago. That was several years ago. We recognized that. The district's other records, as I indicated, illustrate no CEQA compliance for authorities to construct. So maybe there's something in their records, but it wasn't provided to us consistent with our Public Records Act request. And then thirdly, it's just a plant comparison. So the best thing I could do is look at the all-rock asphalt plant. And Mr. Maurer, if you could just go to the next screen. It's just a simple comparison, but it's helpful. So the CB asphalt plant, which is the one that was tested up in Siskiyou County and one that's a subject that's to be approved this year, is a state-of-the-art facility. And it has a single silo to it, which means fewer emissions. It has the state-of-the-art, BACT. It has and that's just up on the screen there, the state-of-the-art BACT that's listed on CARB's clearinghouse, on their BACT clearinghouse, and there's a net decrease in overall emissions when you look at the emissions from this plant when compared to the all-rock plant. So you look over at the all-rock plant, and it was just an old, former time, 2007, so it was older technology. It had multi-silos, and their technology, it's not operating now, but it's outdated. At the time it was submitted, I'm sure it wasn't outdated, but now it would be outdated. And there were much higher overall emissions in their reports that we pulled compared to the testing done on this plant in Siskiyou County. And so based on those factors, that the ATC permit, if looked against the Bay Area Air Quality Management District's criteria, there it would be treated as ministerial, and we think similarly here it fits that criteria and should be treated as a ministerial approval. And then the other point being that according to the records that we'd requested, the district routinely approves ATCs ministerially as opposed to being discretionary action pursuant to CEQA, and we think that that treatment is appropriate here. And one of the issues, I think, from a CEQA standpoint, which we debated whether or not I would mention, but I think now it's appropriate to mention because this morning a commenter indicated that we would be operating with impunity in that we didn't need to comply with CEQA, but in reality, there are about 20 other federal, state, and local regulatory agencies that oversee the operation of this plant and the quarry, and from whom we have to obtain permits. So there's oversight and there's permit compliance. And federally, it's MSHA, OSHA, federal EPA, and the ATF. From the state side, it's the Regional Water Quality Control Board, California Air Resources Board, Department of Fish and Wildlife, California EPA, Department of Conservation under SMARA, CAL FIRE, State OSHA, and OES, the Office of Emergency Services. Locally, it would be the county APCD with the ATC, the authority to construct, that would be issued with conditions. Environmental Health, CUPA, which is the County Unified Planning, you might remember the name of that, but it's the group of agencies, local agencies that oversee environmental issues together. It's a CUPA process.
It's 6 separate programs as delegated to the Environmental Department under California.
Correct. Thank you. Thank you. Jenny Lynn Fire District. And then finally, CCWD. Somebody mentioned, oh, CCWD dropped their opposition. It's because CCWD sat down with us and looked at all of the other compliance obligations that this plant has and decided, let's just write an agreement that says you're going to comply with all of this, and that's what we did. So, and if we didn't, they could come sue us, which they could do anyway if the regulatory agencies hadn't already come after us. So, this authority to construct should be ministerial, because if I were writing a CEQA document for it, the project description would just say it's a self-mitigating project. You have all these agencies, those are the acronyms, which I know you can't really see that the CEQA document would just tell you, you have to comply with all that to mitigate the impacts. So it would be a self-mitigating project, even if you decided this was a discretionary approval. But I believe it should be treated ministerially for the reasons outlined above. Any questions, comments? Yes?
For the Calaveras Air Pollution Control Officer to utilize the standards that the Bay Area Management District has, would the district here have to adopt in advance regulations or a handbook or something that would enable it to do that?
You were looking over my shoulder.
Whoever's
I'll be
got
happy
the-
to answer that question. The answer to that would be yes. We have not, as our own air pollution control district, adopted ministerial standards for permitting. And so I do understand the Bay Area Air Quality Management District has, and as a matter of fact, have done an inquiry to find out how many districts throughout the state have done that. So very, very good point, very good question.
Your answer is no, we cannot proceed ministerially because it would require first the adoption of such a process?
Well, I think that what I would say, just to answer that question specifically, is that we can't treat this as if we were in the Bay Area because we're not that district and we have not adopted ministerial standards for this type of activity. So, I mean, there's other issues at hand as well, but yes, that would be correct. We have not adopted those kinds of standards as has the Bay Area has.
So using discretion in another context, you don't, in your opinion at least, you don't have the discretion to treat this other than a discretionary project?
I would say that that would be my conclusion, yes. And I can go into those reasons as soon as Ms. Kinderman is complete. I'd be happy to answer those questions.
I'm done if you didn't have any other questions.
Okay. And
Thank
maybe
you.
that will clarify
Thank
a
you.
lot of...
No, that was, Kelly stole my one question.
Should I just stand here for a minute?
No, go ahead. Well, I'm sure you'll be back.
That's how we got through a law school.
I feel confident of that. Thank you. Mr. Moss?
I'd be happy to respond to those. All very good points. Thank you, Ms. Kinderman. Again, I would reiterate Mr. Tuno inquired about and Mr. Wooster, and that is, indeed, fortunately or unfortunately, we are not like the Bay Area Air Quality Management District, and we have never adopted standards. The Air Pollution Control Board has never adopted standards for that process. Certainly not saying it's not a good idea, and it's not a bad process. We just haven't done it in this particular district. The other thing that brought up...
But while we're still on the first one.
Yes.
Then All Rock, the All Rock ATC
Yes.
came about
Yes.
how?
I would love to answer that question for you. And I will tell you that if I had the air pollution control officer who was here at the time, I could maybe answer that better for you, but I can't answer it because I did not have the program. I know that that's not a good answer, but the reality is from what I'm looking at, this is clearly a ministerial, discretionary, I know I was going to say that wrong.
Okay.
Clearly a discretionary issue. Should have All Rock probably been called discretionary? I didn't see the application, but I'm thinking you have to treat everybody equally, and yes, but I can't answer for what happened in 2007.
I'm wondering if...
I wish I could.
Yeah, I'm wondering if there's any public record on that issue. Did it come before anybody where there would be some documents that would...
Actually, not to my knowledge. As a matter of fact, we went through the files. My air pollution control technician is here today, and I know that she spent painstaking hours going through saying, well, how did they come to that determination? And then the reality is the files do not reflect any review in a determination, why they issued, or, well, in this case, why they did issue an ATC. So I wish I had a good answer for you, but I'm sorry I don't.
If it's not there, it's not there.
It's not there.
Seems
But
like
we did look. We did look. The other issue I want to bring up is, and it's already been alluded to, is that the Calaveras County Air Pollution Control District does have its own rules. We are part and parcel of the Mountain County's air basin, okay? Like the Bay Area Air Quality Management District is in its own basin. San Joaquin has its own basin. We're part of the mountain counties. What you will find up and down the foothills, you will find very similar rules from district to district. And they're very specific and very different from the Bay Area. Why? Because the emissions are different. So as we see projects like this come on board that we maybe haven't seen in the past, save, of course, All Rock, I think those are things the district has to take a closer look at. But there are existing rules in place. So I want the commission to understand that. Finally...
But you're saying the rules in the mountain district are consistent? I mean, there is a...
The Mountain Counties District has different rules from district to district. However, they are somewhat similar. As a matter of fact, we are part and parcel of what is called a Technical Advisory Committee and a basin control plan, okay, that we meet. And some, I will admit it, there are some districts that are ahead of our district as far as development of their programs. We've made a lot of strides in the last few years, especially as it applies to land use, which I won't bore the commission with today. But it is important to note that, yes, indeed, there are districts in the state that have apparently adopted standards like the Bay Area Air Quality Management District. South Coast probably has as well, although I wasn't able to confirm that yet. That indeed have a ministerial process. I will tell you that our district has 1.25 full-time equivalents. Well, that's not true. Maybe closer to 1.5 full-time equivalents. When you look at the Bay Area Air Quality Management District, you'll have an office full of engineers working on processes like what they've done to develop a ministerial process to literally go through and, yes, check a box, if you will, and say, indeed, yes, it does meet this emissions. Now, hopefully not to confuse this too much further, the district also issues permits for generators, anything greater than 50 brake horsepower for emergency or standby generators. Some of them are continuous use generators for whatever reason. But the reality is when we look at the air toxics control measures as issued by Cal EPA, there is a list. There is a box that we can go to and say, oh, it's this brand, or it's this many horsepower, and therefore this many emissions, and we can plug that into the authority to construct and then ultimately into the permit to operate. Unfortunately, something like this is not something that the district sees every day. And because of that, when we give an applicant what is called, this is an authority to construct application right here, okay? And what this is a guide saying essentially everything we need from the business name on down to what type of emission estimates are you expecting for nitrogen, for sulfur, for carbon monoxide, for volatile organic compounds, for particulate matter, other air toxic contaminants. And it's for this reason that we ask all of this information. Why? Because we need to understand how that plant is going to work, whether it be a packaged plant that is nice and clean, or whether it be something that rolled out from 20 years ago that we're going to scratch our head about and say, do you really want to use this? So I think it's important for the commission to understand that when it comes to an application like this, there's a lot of work that goes into it. There's a lot of fortunate or unfortunate. There's a lot of discretion as to how do we calculate emissions. How long can that plant run? We may be talking about asphalt, but what else do they already have out there? Or, as a matter of fact, what else are they going to be using as part of the process? Do they have a diesel generator? In this case, yes. That's okay. It's not a problem. But when you start adding all of those together, you start coming up with a larger picture. Matter of fact, this application right now, as far as the authority to construct, is still being reviewed by the district engineer, contract engineer. And we've been in touch with him, and he's getting closer to indeed saying, yes, I think we can start putting together some conditions for the authority to construct. Some of those will be identical to what they're telling us they're going to do. Okay? You tell us you're going to say A plus B equals C. We're going to put in condition number 1, A plus B equals C. However, because of either, how many tons you're planning on producing, or other aspects will calculate as to when you can actually operate that plant and how long you can operate that plant so as to mitigate any environmental, in this case, I call public health concerns. So I just kind of wanted to clarify that, and I hope I didn't muddy the water too much.
I'm the least confused that I've been all day.
Oh, good.
I think I heard you say in different words, the county has not adopted a ministerial process for this particular kind of application because there's been no motivation to do it.
I would say that was certainly in part, and I will tell you that the district, I don't want this to sound wrong, but I will tell you the district is much more progressive today, and some of you who have been here for a long time will know this, than it has been in the past. And certainly, if we don't walk away with anything else out of this process, it is to certainly look at, do we look at not necessarily Bay Area standards, because we're not the Bay Area, okay? Just like the people who come up here and complain to me that we have no spare the air days.
No what?
No spare the air days, as an example. I mean, I'm kind of going off topic a little bit, but as an example, we are not the Bay Area. But the reality is do we, and that's why I put out a survey, a statewide survey. Who out there has developed these ministerial standards? Where are they? My My thought is that they're probably the three largest districts, and I can only confirm Bay Area because that's the only one I know of. But San Joaquin is likely, and certainly South Coast is likely, if not parts of South Coast, because when I say South Coast, I do mean Southern California.
Yeah,
So those are the three big players in the state. The rest of us are considered rural.
But if you choose one of the districts
Yes, sir.
that, if anything, has air standards far more stringent than ours,
Yes.
then you're playing it pretty safe.
Oh, absolutely. And I
Southern
think-
California, to name one.
Well, absolutely, and in fact, from land use standards and for looking at projects, it wasn't uncommon at one time that the district maybe wasn't commenting as much as it should be. So what was happening is applicants were taking the real conservative approach and going to San Joaquin. Okay, that is above and beyond what we actually have adopted today as standards. Because, quite frankly, we're not in the San Joaquin Valley. So, and then I promise to stop here, but I think the commission needs to understand that the Calaveras County is out of compliance with, in this case, ozone. Why? Is it because of what we're doing in Calaveras County? No. It's transport from San Joaquin County. How do you control that? And if any of you have the answer to that, I'd really be interested to talk to you after the meeting. But, the reality is we are different than, the mountain counties are different than the valley and certainly different than the coast. So, yes, if you are looking at the Bay Area and we are to adopt Bay Area standards, they would be above and beyond what you'd probably find in the mountain counties in general.
Okay, I do have another question. Mr. Maurer earlier explained to us that when you go through the CEQA door, there's different
Yes, there is.
possible hallways, or different possible turns. And it sounds to me that the first level of the process in CEQA, that may be the only level you need to go to, is in effect the same as a ministerial process would be under Bay Area air management, air quality. Same kind of a process, only you've gone through, you're doing it under the guidelines of CEQA, under the CEQA process, but it amounts to the same thing.
I think if I understand.
Is that overstated?
Yeah, I think if I'm understanding you, I think that what Peter was saying, and I agree, is there are different standards under CEQA, okay? Many people, as this commission knows, will say, oh, you have to do, if you're going to do CEQA, you have to do an environmental impact report, or if it's on federal, you have to do an environmental impact statement. Not necessarily true. There are, and Peter, please jump in if I'm incorrect, notice of exemptions, NOEs, is that correct? And as an example, when we put an ordinance together in my shop, and it had nothing to do with air pollution, we did have to look at CEQA. There are conditionally exempt projects. I don't know what those are, but I would look to Peter to answer those questions. There are negative declarations. There are mitigated negative declarations. So there are different processes, there are different steps up the ladder, if you will, that are part of the environmental review, making sure that the community knows what's going on and what's being done to mitigate an issue.
If this was a ministerial process that you entered into, would that still be a two-party process whereby you're asking the applicant, what can you do about this? And they give you an answer and it satisfies you or doesn't, and you move on.
If this was simply ministerial and I was checking boxes, I may turn to them and say, we haven't seen that generator before. So, in which case, and it's over 50 brake horsepower because you have a nice plant there, we want some further data on that. And sometimes when an applicant gives us data, we will take that data and it literally, part of their application goes into their authority to construct. Because they're agreeing, they're saying, we're going to build this way. We're going to say, yes, indeed, you're going to build it this way. But upon the engineering and the engineering review, you also have to meet some additional conditions.
I understand. I think that's all I have. Thank you very much.
Thank you.
Any other questions of Mr. Moss?
Can you, consistent with the rules you have here?
Yes.
Could you look to those of the Bay Area Quality Management District criteria that they set up for a ministerial
Yes.
decision, but could you look to those when you are making your decision under CEQA about what conditions ought to be in the permit and what level of analysis is required? So it can come in through the back door, couldn't it?
Yeah, I mean, I think that we could look at those, but any kind of standard that would be put into a rule needs to be adopted by the Air Pollution Control Board. So it's not just simply looking at it for a project, let's say, and say, oh, it meets this, it's okay. You have to have the process in place in which you can say, indeed, we have the data, and I go to my charts and I say my NOx is going to be this level, and so many parts per million. My SOx is going to be in this level, and so many parts per million. Okay, I can check these boxes, and indeed, we'll put the conditions in the permit. How the Bay Area is doing that specifically, I don't know. I would have to research that. And again, this is why I've gone out and done a statewide inquiry as to this, because this is actually the first I had ever even heard of such a process, and I've, again, been working with the California Air Pollution Control Officers Association trying to ferret that out.
Okay, any other questions? Well, then I would like to invite, what? Oh, yes, come back on up. Yep, absolutely.
Thank you, appreciate that. Thank you. So just to note, in 2013, Ford got a new generator. The county issued an ATC ministerially for a generator, a 1,000 kilowatt generator that fits in a 40-foot semi-truck trailer with the ministerial process. And so in reality, that was treated ministerially and not as a discretionary approval. The other thing I'm concerned about is the conclusion that an agency must treat all permitting as discretionary because it hasn't adopted any standards, that it is precluded from treating any permitting ministerially, and that isn't really the case. An agency is certainly able to look at how another jurisdiction might treat an issue and make their own findings as to why they have chosen to borrow those standards and why they would apply in this community. Maybe not the Bay Area, maybe not San Joaquin County, but the county would be hogtied in terms of all permitting simply because they don't have standards and everything. Everything would have to be discretionary. So we can't leap to the conclusion that just because standards have not been adopted, that everything has to be discretionary. I don't agree with that legal conclusion.
Adopted is kind of the key word here. Adopted how? Adopted because someone said, hey, that county's doing a we like the way their county's doing it, let's do that here, and it's administratively through a department
Right,
head.
they could
or
do
adopted by bodies like this one and boards of supervisors. I mean,
What I'm saying is internally, an administrator could decide to borrow those, that template for their own use. But they could also want to incorporate it into their own ordinances and then come to the commission and ask the commission to formally adopt those. That would be a separate process. But as an administrator of an agency, they can choose to borrow and make their own findings as to why they did that. Internally, we have decided to use the standards of the mountain, whatever that APCD is, and that it's appropriate for this. They would create a record on that, and I don't think they would have to take that to the commission unless they wanted it done formally for all purposes.
well, that was my question of Mr. Moss earlier, and so now we got two different answers.
Right, we do. And I don't know if Ms. Moss-Lewis has any thoughts on that as well, but I know in jurisdictions we've represented, it's been done that way. It does not automatically, it's not a leap that because there aren't some fancy standards in your ordinances, that everything becomes discretionary.
Well,
I
wouldn't
guess-
it be discretionary, though, with the choice of whose standards to borrow and look at and adopt? Wouldn't that itself be a discretionary function?
I haven't thought about that. I don't think so.
May I comment on the generator?
Sure.
And I would agree with Ms. Kinderman on that. And we did permit that. We did do an authority to construct on that initially. Again, that goes back to the air toxic control measure that I was talking about as put out by CARB, or I should say our ARB. CARB is an old acronym. And certainly, yes, those are a lot easier, and those are much closer to a ministerial action because I have a template to look at. I have a checkbox to go by. And so when it comes to those generators, and that's a pretty big one, by the way, absolutely. It was a non-issue. It wouldn't rise to this level. So I actually do agree with you on that. And so not every single thing that we do, again, requires the amount of discretion and the analysis that this particular project does. If I have 150 generators in Calaveras County, and I permit them annually, and we do, and are all over 50 brake horsepower, are the standards different from one generator to the next? Yes. Are they significantly different? Some of them are. It just depends on what it is. But what is the key? I have something to go to in law, something to go to in code that says that's tied in with my district that allows me to point at that and say, yes, indeed, I can permit that, and these are the conditions because they've set the conditions. I adopt those conditions, and those conditions are taken right off of the air toxic control measures. So I just wanted to clarify that. So that is why that was, the
Right.
ATC was issued.
And it also said in the June 25 staff report that you may, and other agency heads may make decisions based on their own knowledge and experience as well. And so similarly, if their knowledge and experience led them to conclude that the Bay Area standards or mountain standards or San Joaquin County standards would work well in this scenario, they could certainly make the finding using their own judgment and experience on this particular issue, as was specifically articulated in the June 25 staff report.
I would have to say that those types of things, and I think maybe we're getting a little off track here, but the reality is if it's not in my rules as adopted by my board, I have one of two options. I can go to my board, my air pollution control board, and ask them to adopt either a new rule or adopt a change in a rule to do that. But I cannot, and I do not just unilaterally override what my rules allow me to do.
Thank you. Thank you for your time.
Thank you. So at this time, I'd like to welcome members of the public that would like to address the commission. Might I, a couple of reminders. Wait a minute, I wrote them down. Don't forget to sign in. That's important because Annette cannot always understand when you're at the microphone, your name, so it would be helpful for her. Again, 5 minutes per speaker. We're only speaking once, so make it good.
Marty Crane, Valley Springs Rancho area. I just wanted to share in response to the little conversation that we've just been having about adopting rules from other areas and just doing it in-house in this office. Well, this is the public, and they've come and gone, and we've had some that had to leave because they couldn't stay any longer. Some have come to other meetings and they can't come today. But then some have written letters because they couldn't come today. But we all consider ourselves your partners. We are all partners in this process, or at least we hope that we are, because we still anticipate, for the moment, that when we come to this podium and we share our skills, our experiences, our research, our hopes and dreams for the quality of life that we enjoy and hope to maintain here in Calaveras County, that our words will not fall on deaf ears, that they will be heard. And I've attended probably every Board of Supervisor meeting since 2002 or thereabouts. And many, many departments, probably all of them at one time or another, have come and done presentations. And at all times, I recall, when the public comes and asks a question, they make a note of it. And they have this list. Sometimes it gets pretty extensive. When you have questions, you ask and you get answers. If the answers aren't in the room, you call, you postpone, you call in resources, whatever. When the appellant asks questions, they get answers. When the public asks questions, we're not getting answers these days because I think there's not a list being made. And I think it's important that we get answers to our questions. And I understand that when I ask a question right now, you can't stop and answer my question because we'd be here till midnight. But at the end of the public comment, then that's when staff generally goes down the list of questions and answers all of them. And then they go, did we miss any? Because sometimes they can. So that's my, we're going to hear from the public. We've been hearing, and I'm hoping that you will go back and answer their questions. Thank you.
Thank you. I know we try and do that, but I'm sure we can do a better job.
Well, it's just, I think it's the planning department
Well-
that hasn't been making a list.
Okay,
That's my-
thank you.
Brock Estes again, speaking as someone who did not have his question answered previously. May I first ask you a procedural question? I'm unclear as to how many items we're considering today and thus how many times we'll be having public comment. Would this be the only time, or would there be another item and more public comment?
Well, this is it, and there are 2 items, so you would need to
Okay,
address
so if we
both
want to
of them.
talk about environmental quality, we have to do it now, even though it seems like you're debating a very narrow subject that really isn't much about the actual quality of the environment.
That's true. We're talking about an authority
Yeah.
to construct, and if it is a project under CEQA.
Right, and I'm perfectly willing to address that, but in that case, when are we going to address the actual environmental issues?
I don't know, Mr. Brock. I suppose if there is an appeal to a decision having to do with hazardous materials, then that would be, we would be
Well-
talking about environmental issues then.
So I've used up half my time, so I don't have time to go into the environmental issues, which are substantive. So I'll start from the letter that the attorney for Ford wrote on 6/24. I believe she said there had been no new information provided since May 29th, but I found much new information in that letter of 6/24. I may be incorrect, but I think she is saying she sent it once and on May 29th and then sent the same thing again, but I've read that letter and it doesn't say this is another copy of that letter. So she would have been in error if she said that. In that letter, I noticed that she stated as fact that there had been an asphalt plant on that premises many years ago. Now, Mr. Maurer stated that in his opinion there had never been one there. I'm just kind of wondering if anyone asks her to support her facts with information. That would have been one. In this particular issue, she mentioned filing a Public Records Act, and I'm unclear as to whether she said she got no response or that there was nothing that met her questions. I think as a board member, I'd ask her for a copy of that public records request. That way you can see what she asked for and the response from the agency as to what she got. Lastly, the Siskiyou tests. I'm really unclear how these are done. Are we talking about 1 cubic foot and what's the amount of emission there? Or are we talking about the overall total of emissions generated? Because in what I read about the tests in Siskiyou, they're dealing with a far smaller plant putting out far less asphalt per year than is presaged for here. So if we're looking at, look, Siskiyou, we were only at 50% of the allowable limit, but we're putting out 3 times as much material here. Is there an overall amount of, say, particulate matter that is tested, or is it tested narrowly by the cubic foot? So personally, I don't have the answers to any of these, but they're questions I'd like to hear answered. Thank you.
All right, thank you.
My name's Terry Henderson, and on June 25th, in a regular Planning Department meeting, Mr. Tuno stated that the environmental concerns, health, and property value should not be a concern for consideration of the residents living near the Hogan Rock Quarry. Mr. Tuno informed us that he researched and found there are hot asphalt plants in Tracy, Santa Rosa, South Lake Tahoe, and along the McCallum River in Clements. I have done some research in the Tahoe Asphalt Plant, located at 1104 Industrial Avenue in South Lake Tahoe. The hours of operation there are 7:30 a.m. to 5 p.m. This business is in an industrial area of the city, not in the residential area. It is a small operation that produces from 1 ton to 1,700 tons maximum daily production. It is an asphalt supplier. They have a daily production limit. That is a big difference to what is being proposed in our backyard. Mr. Tuno stated the asphalt plant in South Lake Tahoe is across the street from homes, and that wasn't quite accurate. Tykert Aggregates, they are located at 36314 Southward Road in Tracy, California. This business is located over 7 miles south of Tracy, California. The hot asphalt plant is not 1/4 mile from the residence, as Mr. Tuno stated. The plant is near the junction of Interstate 580 and I-5. This is a rural area, no homes or subdivisions in this location. They do not have any mountains to trap the toxins and pollutants like we do in our residential neighborhoods. I telephoned Tykert Aggregates in Tracy, and they told me all their asphalt is manufactured at the plant on Southbird Road. Their business office is located in the city of Tracy. So maybe they are not affected by lower property values or health concerns, since they are residents of Tracy, are so far away from the manufacturing of hot asphalt, unlike that which was being proposed in our residential area. Bodine Asphalt Plant, Santa Rosa. I called them for information. The plant has hours of operation set for 7 a.m. to 4:30 p.m. Their asphalt is manufactured in the Industrial Business District, which is in the Santa Rosa city limits, not far from Interstate 101. The asphalt plant manufacturing is not done at the quarry. Quarry rock is trucked to the asphalt plant. The Santa Rosa plant uses rock supplied from 2 separate rock quarries, Mark West Quarry Bodine Company and the Bodine Forestville Quarry. The residents living in the vicinity of the asphalt plant do complain of health concerns. Ford Construction of Valley Springs wants to expand their hours of operation, 4 a.m. to 6 p.m., and include some 24-hour production. Santa Rosa and others can produce asphalt away from their rock quarry, so why do we even have to consider producing hot asphalt in a residential area at our Hogan Rock Quarry? Somewhere in my research in the past few weeks, I came up with a quote and made me think about the way things were presented. First, get the facts, then you can distort them as much as you want. And that was by Mark Twain. I suggest in the future, if you do not have the facts, please do not pretend that you do. The residents of Calaveras County and Rancho Calaveras do have legitimate concerns. We will not go away or be bullied. Our roads are not designed for the additional trucks. We are not willing to risk our water quality. And we do need CEQA to protect our residents. Please consider the facts before you rubber stamp a business that was quoted in a letter to the Calaveras County Air Pollution Control District dated May 18th. Application for authority to construct. I will quote a section of that letter. CB Asphalt Inc. is planning to utilize its portable hot plant in the Foothill Quarry to furnish hot mixed asphalt concrete to Chester Bros Construction for 3 Caltrans projects currently under contract, as well as the forthcoming Highway 4 Angels Camp Copperopolis project. Additionally, CB Asphalt Inc. plans to offer cost-effective hot mix asphalt for sale to local Calaveras County contractors and the Calaveras County Road Department. Wow, that sounds like a conflict of interest. Are you able to remain objectionable in your decision to determine whether or not this will be an asset to this county, or are you looking to the benefits of cost-effective hot mix asphalt for sale offered to the county government by CB Asphalt, Inc.? Please do the right thing and keep the hot asphalt plant away from the residential neighborhoods. Protect our homes, health, and our residents. We moved into a residential area, not an asphalt plant. The taxpayers deserve to be protected. Please do the right thing and vote no to the hot asphalt plant at the Hogan Quarry or Foothill Materials Quarry, whatever it's being called. Once again, we'd like to deliver the signatures of Calaveras County residents who oppose the addition of a hot asphalt plant at the Hogan Quarry. On June 25th, we delivered
I'm sorry,
350
you've got about 30 seconds, thanks.
Okay. 355 signatures today. We are adding to that number. Online, we collected 313 signatures in opposition of the asphalt plant, and we are also presenting you with an additional 116 from the Calaveras County residents who are opposed to the hot asphalt plant. Today's total is 429 for a grand total the past 3 weeks of 784 signatures. These are not just names on a piece of paper. These are real people who are concerned with their homes, health, and their way of life. Many of these people are at work and could not be here today, but want their voice heard. Thank you. And I have
Thank you.
copies.
Next.
Joe Kelly. No offense to the appellant. My money's on this man right here, Brian Moss. As long as I've known him, I've never seen him go off track. He gets to the bottom of things and presents it. So I hope you folks are paying close attention to him. Thank you.
Thank you. Anyone else? I'd like to invite the appellant back in.
To maybe answer, if you have any, there is one question I could ask you that was raised about I think he said June 24th letter that there was a previous asphalt plant on the site?
There was a batch plant on the site. Correct.
Is that asphalt?
But we had 2 approvals for hot plants.
So, but has there ever been a previous asphalt plant on the site? Okay, thank you. That answers one.
Thank you. Thank you.
And then as far as the Public Record Act findings, you pretty much showed those in the slide. Isn't that correct, that you had?
The last slide, that was just a summary of our arguments,
Okay.
but what I said was we had submitted a Public Records Act request, wanted to see all the CEQA that had been done on all the ATCs in the county, and we got nothing.
Okay.
For like 5 to 7 year period of
Okay.
time. We didn't want to make the time frame unreasonable, but knowing that there's also been an economic downturn, we wanted it to be long enough that maybe someone had submitted an application, and none were provided to us. So some ATCs must have been permitted without, or maybe there weren't any permitted, but we didn't get any CEQA
Right.
documentation at all. So we just drew the conclusion that there wasn't any,
Right.
that they were not treated as discretionary, but as ministerial.
Okay. And then, as far as the SISQ test goes, you
Yes.
just provided those as far as an example of the sort of technology that you would be using.
Well, okay, so, and this was submitted to Mr. Moss, to the department. The facility was used up in Siskiyou County, and so specific tests had been run on all the different air quality constituents, NOx and what have you. And it just showed what those emissions were. And those have been provided to the county. And so they, in terms of the county standards, as I indicated, they were way below, like less than 50%. It was a very clean plant. And that's the plant that is here waiting for its authority to construct.
Okay, thank you.
You're welcome.
Are there any questions of Mr. Worcester?
Did your Public Records Act request ask for all the ATCs for asphalt plants that were issued in the last 7 or 8 years? Not just those with CEQA?
Yes, and not just for asphalt plants, just authority
Any-
to
any-
construct for which there were CEQA, was CEQA. It was they're broad. The Public Records Act requests need to be both broad and specific.
How many authorities to construct were issued for asphalt plants?
I don't know. I don't know.
So if there weren't any, then that doesn't mean there were ministerial approvals.
I don't know, because I had my associate go through those and let me know were there any secret documents. They said no. I didn't spend the time looking at each authority to construct. So I don't know the answer if there were 6 of them sent to us or not. All I know is there's no secret documentation. I didn't want to, it wasn't an issue that I felt I needed to spend the client's time on. I just said, let me know if there's any secret documents, and there weren't. And so in drafting the letters, which the associate helped me with, he said there weren't any. There was no CEQA provided. But in terms of how many ETCs there were, I can't tell you that. Sorry. Well, yeah, All Rock was one of them, but we all know that we've mentioned All Rock, and there's the All Rock, which is what we've compared here, that was issued in 2007 without any, and that was ministerial.
Did they
Pardon me?
ever produce any AC there at the All Rock plant?
I don't know, I don't represent them. I do not know.
So as far as we know, there
we
was
would like
only
to be
one
treated
ATC for an asphalt plant that was granted in the last however many years, and that was All Rock.
I know that was one provided to us,
Okay,
yeah.
so we don't really have a big practice of ministerial handling of these things with just one example.
And just
That
for-
is one example that we have, yeah.
And just for
Sorry.
clarification, just like I stated to Ms. Kinderman before, there are some ATCs, many of those ATCs were actually for generators. Again, we're not a big district, and most of those generators, quite frankly, are tied with the Calaveras County Water District. So that's why she wouldn't have been seeing discretionary actions on an ATCM-based permit.
There's been significant prejudice to the operators in waiting for these decisions, and we're trying to work with the county in getting these decisions made so that they can find out if they're able to proceed with this plant, and they'd like to be treated equally with other businesses in the community on equal footing, and would hope that would be considered, so.
All right, thank you very much.
Thank you for your time.
Thank you. So is there any in the public that hasn't spoken that has to address the commission? Okay, I'm going to close the public hearing. I can't even talk anymore. I believe I had everything written down, the answers that I had.
Except for Terry Henderson was basically,
The only answer I didn't get was, can we ask for a copy of the public records assessments? I'm not sure if she's saying they didn't respond, or they responded and said, we don't have anything. Which is...
I can answer that question.
Wait,
Yes, we
we've
did
got a
respond.
response here from Mr. Moss.
I'm sorry. Yes, indeed. We did respond, and we did submit the information. And in part, that's what she was talking about with the authority to construct applications in the ATCs I was just discussing. So yes, indeed, we did release a lot of information pursuant to the Public Records Act.
you released information on ATCs
Ken-
to her from her public request?
Yes.
Did you receive them, Mrs. Kinderman?
Yes.
Yes, I did. Yes, I did